Hi everyone, welcome to Just Stripper Things. You may already be following some of the news about the most recent challenge to Canada's sex work laws. And I am here to tell you that it's literally the same shit in a different decade. We have already fought this battle, we won, and the Conservative government dropped a dirty bomb. Bill C-36. Just as a general note, in some direct quotes, the word prostitute will be used, but keep in mind that it is not the correct term. Please use sex worker. Instead of prostitution, it's sex work. It's less derogatory, far more descriptive, and doesn't hold the same stigma. In case you haven't seen History of Sex Work in Vancouver Part 1, where we discussed the communicating provision enacted in 1985, the effect of that provision is summarized by appellate justices in a dissenting opinion. The 1985 edition of the communicating provision, Bill C-49, created an almost perfect storm of danger for prostitutes. Prostitutes were first driven to the streets and then denied the one defense, communication, that allowed them to evaluate prospective clients in real time. The other fact of the matter is that there is a huge difference in how indoor and outdoor sex work are policed. The Canadian Centre for Justice Statistics released a report in 1993 that illustrated clearly this disparity. The statistics show that out of over 10,000 prostitution-related incidents reported in 1992, 95% were communicating offenses. Bawdy house and pimping offenses made up only 5%. They said that with this bill, you're going to drive us so far underground and make us work under such difficult conditions, the violence is bound to escalate. And of course, they were right. Driven into the downtown east side, into poorly lit industrial areas, away from witnesses, away from support systems, and into the hunting grounds of Willie Robert Picton. That's why it's so important not to forget that history. On December 20th, 2013, the Supreme Court of Canada unanimously ruled in favor of Terry Jean Bedford, Amy Leibovich, and Valerie Scott in the case of Canada v. Bedford, striking down 3 provisions of Canada's criminal code. Keeping or being found in a bawdy house, living on the avails of prostitution, and communicating in public for the purpose of prostitution. Terry Jean Bedford, Amy Leibovich, and Valerie Scott had argued that these laws were preventing them from using bodyguards and drivers, working inside private homes, or talking with and thereby screening clients in public, all factors that would be essential to their safety. The Attorneys General of Ottawa and Canada claimed if the conditions imposed by the law prejudice their security, it is their choice to engage in the activity, not the law, that is the cause. And that's why other workplace safety laws aren't a legal consideration, nor should be legislated. Right? Plenty of activities, you mean jobs, are hazardous, and yet we don't legislate them to be even more dangerous than they have to be. Justice Beverly McLaughlin wrote, "Parliament has the power to regulate against nuisances, but not at the cost of the health, safety, and lives of prostitutes." The prohibitions at issue do not merely impose conditions on how prostitutes operate. They go a critical step further by imposing dangerous conditions on prostitution. They prevent people engaged in a risky, but legal, activity from taking steps to protect themselves from the risks. The decision allowed 1 year for Parliament to update the laws in accordance with the ruling. I would not be the only person to argue that they failed to keep in accordance with the ruling at all, and completely failed to protect the charter rights of sex workers. If the Harper government rewrites laws, they will fail, and the next generation of sex workers will be right back here. And here we are, Bill C-36, the Protection of Communities and Exploited Persons Act, was passed by the former conservative government in December of 2014. It reflects the Nordic model, which makes the purchase of sex illegal in an attempt to end demand. There is no evidence that it has actually worked to achieve that goal, and many argue that instead it pushes the industry further underground, which makes it more perilous. Bill C-36 also repackaged the previous laws in shitty new wrapping. Living off the avails? Now it's called material benefit. While its intended target may claim to be pimps, the collateral damage is that sex workers still can't hire drivers or security, can't operate out of a brothel, or work for an escort agency. Communicating? They didn't even bother to rename it. It's still communicating, and it pertains to any place where the public have access as of right or by invitation, whether express or implied, including a motor vehicle located on a public road or open to public view. Here we are again. There is no logical justification for this. Research has shown time and again that this is not a logical or informed course of action. For example, New Zealand decriminalized sex work in 2003, and a 2008 study found that working conditions for sex workers were improved and that they were more willing to report acts of violence and abuse to the police. I don't think you could read the social science evidence and hear what sex workers are saying about how to keep themselves safe and the fact that they want decriminalization and think that C-36 responds in any way to any of that. I think the law that prohibits the purchase of sex will drive the whole industry underground, will force street-based sex workers into dark and isolated parts of our city, will make indoor sex work virtually impossible. Since 2014, sex workers have reported increased antagonism with law enforcement, targeted violence and fear of reporting, unwanted and unsolicited police interactions, and targeting of Indigenous, Black, trans, and migrant sex workers, as well as sex workers who use drugs. The fact that clients are criminalized still makes things extremely dangerous for sex workers, because it makes clients not want to meet in more public areas, and it just drives the work further underground. Simply by attacking the Johns, you're not making anything safer for the sex workers, and in fact, you're driving the trade further underground, and anything you drive further underground is less secure. When legislators try to claim that these laws are supposed to protect people from trafficking, it's a completely disingenuous claim. Weak labor protection laws and conditions where cooperating with police can often be detrimental are ideal for trafficking. Police repression against the sex industry does not address this issue and actually creates conditions that encourage trafficking. The best way to fight trafficking in any industry is to make sure it is safe for victims and witnesses to come forward. We are not allowed to collect money from sex workers, and we are not allowed to collect money in order to promote their business in any way. That's what a professional association or union would be doing. We would be breaking the law. We all enter it for the same reason, that we have things to pay for. We have rent to pay for. We have food to pay for. You know, we enter this work just like you go into any other job. So it forces us into the shadows, and we're more likely to work with criminal activity where our rights aren't respected. Rest in peace, Jamie Lee Hamilton. You will be missed. You were awesome. We all have moments that we remember vividly. Where we were, what we were doing, when we heard the news of a defining moment. For me, it was this, when the Harper government played us. I remember watching the news in my dermatologist's office, trying to keep silent while I was watching it all unfold. My stomach sinking, great heaviness upon me, seeing that this was just the same shit all over again. I was just a retired stripper. This wouldn't even affect me personally, but I couldn't help but think of all the people that would suffer because of it. Suffer so needlessly. Knowing that even though Terry Jean Bedford, Amy Leibovich, Valerie Scott, their legal team, and everyone behind them fought so hard and won for nothing. It was so disheartening to see that even when we win, we lose all over again. The fight for sex workers to have the protection they are entitled to under our Charter of Rights and Freedoms is just the boulder that keeps rolling back down. But we'll keep pushing. In 2015, Fantasy World Escorts was raided and shut down, and the two owners, Tiffany Harvey and Hamad Anwar, were charged with procuring, advertising, and materially benefiting from the sale of someone else's sexual services. Initially, they were also charged with human trafficking. Human trafficking. You keep using that word. Thankfully, logic and the understanding that words mean things prevailed, and those charges were the first to be dropped. When you look at this from the perspective of the sex worker, they can barely take a step left or right without being charged with something. They can't make themselves safe, and they can't hire third parties to do it for them. Third parties are not always excellent, but they provide screening. They ensure that you're in contact with people. Quite simply, having someone know where you are and that the client knows that someone knows where you are, that reduces risk. Fantasy World Escorts had a code of conduct, including instructing clients to use condoms. It advertised salaries of up to $5,000 a week, vacations, health and dental insurance, and tuition subsidies for students. The law against material benefit doesn't allow sex workers to pool their resources or work in a managed, safe environment. It doesn't differentiate between legitimate business relationships and exploitative practices. It targets both equally, conveniently seeming to forget that an exploitative relationship would be dealt with under the criminal code as trafficking. In February 2020, Justice Thomas McKay ruled that the charges against the owners of Fantasy World Escorts were unconstitutional. Legislation for which the stated purposes include eliminating exploitation and reducing the risk of violence to sex workers actually has the effect of exposing sex workers to an increased risk of exploitation. While he noted that his decision was in regards to only this case, it does set a precedent, and the ruling may be referred to in other cases. This judgment is very important for sex workers. It enables sex workers to have proper protection in their profession. They can set up their own cooperatives to protect each other. They can hire expert managers to make sure their business is run properly, and it allows them to get off the street, which is the most important thing, because that's where sex work is most dangerous. It's very likely that the Crown will appeal and that the case could land at the Supreme Court. Once again, it would be a fight to get the same types of laws struck down. Hopefully, the precedent has been set by Canada v. Bedford, and the fight will be easier, since we basically already know that the laws put forth in Bill C-36 are against the Charter of Rights and Freedoms. As for the current political climate in Canada, it's somewhat hopeful, since the Conservatives aren't in power like they were when C-36 was passed, but we're not holding our collective breath. Even though Justin Trudeau voted against Bill C-36, neither he nor the Liberal Party have taken any steps to repair the damage that has been done. The only Canadian political party that mentioned sex worker rights in their campaign platform was the Green Party. As we saw in the House of Commons, in the Marilyn Levesque video we recently put up, the NDP seems to be in our corner, but we're still stuck at this weird impasse until this most recent case hits the Supreme Court. As we wait for that to happen, we can continue to fight for sex worker rights, recognize that sex work is work and that sex workers deserve the same protections under the law as every other worker. Strip the stigma. Thank you for watching. Mash that subscribe button. Tell us your thoughts. Do what you want. And I really, really hope that somehow the editing makes it look like I'm not just wearing a shirt that says Nazi, because it actually says bye.